Good morning, everyone. Today is the second day of the engineering and construction contracts lecture. And today we will focus on construction dispute resolution. As it's 10:05 now, so I think most of the attendees have joined. So I think we can start. Okay, here we go. You can move on. Let's do it to the next one. No, this is the content. Okay, so just to look at the contents quickly, we'll focus on the claims proceedings under the standard forms of contracts today, specifically with focus on the claims processes for contractor claims and employer claims, how that then follows into the determination process, and if the determination is disputed or the parties are dissatisfied with the determination, what follows after that. We'll look at the alternative dispute resolution proceedings that are generally available under construction contracts. We'll look at dispute avoidance, and then we'll focus specifically on the standard form contracts and the dispute resolution proceedings that are addressed in those different standard contracts. Okay, so the first topic we'll look at is claims and determinations, just an overview, what it's generally all about. So as we've discussed yesterday, there are in the contracts the risk allocation to the different parties in the contract, and the contract then specifically provides for the remedy available to the party that suffers a loss as a result of that obligation or risk event, that if it is not properly managed as per the requirements of the contract. So the nature of the claims in these construction contracts are generally in relation to an adjustment to the program for delays or the extension of the time for completion, and then also secondly for additional costs. And as we've looked at the different contractor claims or contractor risk events and employer risk events, one can really say that they are generally a predetermined risk event that entitles the employer, the contractor, to relief for such an event if it's not properly managed. So, for example, the employer would generally be entitled to delay liquidated damages. This is the damages that is a predetermined penalty that will be imposed by the contractor. By the employer if the contractor fails to achieve completion of the works. And the reason for that is that penalty will cover the loss that the employer would suffer if the works are not timeously completed in order for the employer to use the works for the intended purposes and to generate an income from that works. The other claim that you would generally see is an extension of the defects notification period, and that's generally if the works are not ready to be used for the intended purposes by reason then the employer can claim an extension of the defects notification period. Predetermined risk events for contractors is where the contractors are generally entitled to relief from the performance of its obligations, and that is when it is hindered, prevented or delayed by events that falls outside its control and result in a delay or then additional costs. And as we've looked at these events yesterday, those generally include force majeure claims that can cause a delay or additional costs, where there are a lack of access to site or in instances like where it's a change in law that impacts on either the costs or timely completion of the project. So each of the standard forms of construction contract provides for a specific procedure that the parties need to follow if either one of the parties believes that it is entitled to claim relief in terms of these events. And so we'll have a highlighted look at the process that needs to be followed in these contracts. So firstly, the claim process generally includes delivery of the notice of the claim. That would then be followed by particulars of the claim and the claim will then be assessed, and the principal agent, the agent or the engineer would make a determination, depending on what contract is applicable. And you will see that the contract generally has a specific requirements in terms of what those different documents need to look like. So, for example, notices. The notice generally the party needs to give a notice, and the notice needs to comply with specific requirements, such as that. Firstly, it needs to include a reference to the particular clause that the party relies on for its specific claim or relief. And then the notice also sometimes needs to be delivered within a specific period of time. The notice then should sometimes also include, typically it always requires details of the claims that needs to be specified in the notice. Once the notice is delivered, just to say generally, the notice is required to put the employer or the contractor in a position where the risk event can be properly managed by either one of the parties, and to mitigate the consequences of that event. So once the notice is then delivered, the party who is claiming should deliver particulars of claim. The particulars of claim will also be subject to time bar provisions where it is submitted out of time. But that again, it depends on what contracts you are looking at. Generally, the particulars of claim need to show supporting evidence of the claim, including details on the quantum, if there is quantum that is relevant to the claim. So often you would see where there's an extension of time claim, there should be a revised program that indicates what the impact was on the completion of the works in terms of the previous program. And where there are costs, usually there would be a requirement to submit bank statements or any supporting evidence that constitutes that costs were in fact incurred by the party that's claiming the return. So then the following step is the determinations. So once the particulars of claim is submitted, the employer or the agent or the engineer, depending on what contract is applicable, will then consider the particulars of claim, and it will make a determination based on the documents that were presented to it. A determination for money is mostly given effect by the agent in terms of the next payment certificate. So once the determination is issued, that determination, if it's like I said, a determination for money, the money will be reflected as a payment in the next payment certificate through the inclusion of the additional sum that's due to either the contractor or the employer. A determination for additional time is mostly given effect by extending the date for completion of the works, the acceptance by the employer of the revised program to complete the works, and for the employer then obviously not to impose any liquidated damages should it then have been entitled to the liquidated damages. Just some general thoughts on this process in terms of claims is that record keeping and updated programs are generally essential in order for the engineer, well, firstly to support the claim, and secondly for the engineer to make a proper determination of the claims. And then one other consideration in practice is that if there is more than one tier of contract relationship between the parties in respect of a specific project, it's important that the claim regime for specific events flows through from the higher tier to the lower tiers. So in other words, there should be a flow through in respect of the relief that would be entitled to. In those scenarios, generally where there's a determination in the higher tier in respect of a specific event, such as extension of time claim, that determination will then flow through to the subcontract relationship. So that's why, again, as we discussed yesterday, it's important for the provisions to correspond with the higher tier provisions, specifically in relation to relief. So in respect of those flow-through claims, it's also important to highlight to a contractor that the employer's claim would always be as strong, or in most instances, be as strong as the contractor's claim, because usually the contractor is much closer to the facts and the event that occurs on site in order to provide the supporting details of that particular claim. So if the contractor's claim is not providing the necessary supporting details to substantiate its claim, the employer may also struggle to find it challenging to support its claim in terms of the higher tier claim provisions. Okay, so now we're moving on to look specifically at the notices and just giving an overview of notices generally. So the general rule in our law is that a demand for non-performance must be delivered to place the defaulting party in breach if it fails to, for example, remedy a default within a reasonable time. So in construction contracts, besides just being required to demand for to remedy non-performance of an obligation, notice is required when there is a claim for additional compensation or extension of time. Like I've mentioned before, the reason for that is simply because if no notice is given to the engineer or the agent of the employer, it would be difficult for the employer to actually manage the risk and to mitigate the consequences of the event that results in a claim. So notices can generally be classified into three categories. One is a simple obligation, a condition precedent, and that specifically features in the FIDI contracts, or a time borrowing provision. And I'm going to go into more details about those three categories. The consequences of a failure to give the notice will depend obviously on the category of the notice in each case. Non-compliance of a notice provision, which is a simple obligation and nothing more, will not necessarily cause the contractor to forfeit any rights it may otherwise have had to additional compensation or extension of time. So, for example, it's just when simply a contract clause states, in the event that the contractor encounters adverse subsurface conditions that may give rise to a claim for additional compensation and/or extension of time, the contractor shall notify the engineer of such conditions in writing. So that's just the way it's usually phrased when it's a simple obligation. Either when the employer can show that it was prejudiced by the contractor's non-compliance by the contractor, and that as a consequence, the contractor should not be granted the additional compensation or extension of time claim, the contractor's claim will be reduced according to the harm that the employer suffers as a result of that failure. So in terms of the simple obligation is where the contractor does not provide such a notice and later claims additional compensation and or extension of time. The employer may well then argue that had the required notice been given, the engineer would have had the opportunity to alter the design. So again, it comes back to the risk mitigation of the consequences of the event if it arises. So the second category, we say there's a notice provision, which is a condition precedent, which must be complied with before the relevant claim becomes ripe for consideration. An example of that would be, I'm just going to phrase it, is in the event that the contractor considers that the engineer's instruction will cause additional expense for which it will require compensation, the contractor shall notify the engineer in writing prior to the executing prior to executing such instruction of its intention to claim such additional expense. So if no notice is given by the contractor before he carries out the instruction, the engineer will be fully justified in believing that there will be no claim for additional compensation. So such a clause is either not an absolute bar. To the extent that the contractor can demonstrate that the employer has not been prejudiced by the lack of the notice, the contractor may well succeed in claiming extra expenses and which should reasonably incurred. And then a time borrowing provision, which we all, I would assume, is familiar with in the FIDIC contracts, provides that a notice be given within a certain specified time period, finding which the entitlement that the contractor has will be extinguished. Such clauses may be viewed as extremely harsh, and as a consequence, courts will generally interpret those clauses very strictly. So in the event of there being an interpretation which will have a less harsh consequence for the contractor, the court will generally prefer such an interpretation. An example of a time borrowing provision is that in the event that the contractor incurs standing time as a result of any event defined herein as an employer's risk, the contractor shall, within 14 days of commencement of such event, give written notice to the engineer of any intention to claim compensation therefor. Failure to comply with the provisions of this clause will cause the contractor to forfeit any entitlement it may have had to such compensation. So just to highlight some of the typical things that one needs to look out for once you prepare a notice on behalf of your client, is that one needs to look at the contract and look at what the notice should look like, because the contract would have particular requirements in that regard. Secondly, whether it can be sent by post, fax, or email, and there might be a specific requirement in terms of when a notice will be deemed to be delivered. So those provisions need to be carefully considered. But thirdly, one needs to look at what information needs to be provided in the notice, and that should be carefully set out in a draft notice. And most importantly, the time limit for sending the notice. It often happens on projects that everyone is so involved in actually performing the project that it's sometimes the administering of the claims falls by the wayside, and the compliance with those time periods are not complied with, which obviously causes a risk to succeeding your plan. Our court's consideration of a valid notice is based on the substance and content of the notice, and not really the form. So even if the notice is sometimes in the form of an email, which is generally informal, the courts must still consider that as a proper notice, subject to it then obviously have the necessary content and information. Our recommendation is obviously to always have a very cautious approach when one drafts a notice, and not to end up in a debate about technical things such as whether it needed to include a reference to a clause or not, and what the consequences of that would be. So one should carefully apply the requirements as per the contract in terms of the form and the content when you draft a notice. So now we will move on to consider the claims processes under the relevant standard or the standard contracts. Firstly, we'll look at the FIDIC contract. and how the employers and the contract claims are dealt with under those contracts. So you will see in the slide that the red book, yellow book, and silver book is dealt with on one heading, and the reason for that is because they are generally the same. So yeah, let's jump into the employer's plan. Clause 2.5 in the FEDEC 1999 edition is dealt with under clause 2.5. So firstly, the employer's claim also needs to, well, it needs to follow, or it should be initiated by a notice. So if the employer considers himself to be entitled to any payment or an extension of the defects notification period, he will give a notice and the particulars of the reason why he'd be entitled to a claim to the contractor. The FEDEC is also very specific in terms of which claims do not require notice, and the FEDEC there states that a notice is not required for payments due to subclause 4.19, which is cost in respect of electricity, water, and gas. And then also 4.20, which refers to or deals with employers' claims in respect of employers' equipment and free issue material, or for other services that's requested by the contractor. So moving on to the timing of the notice, because as we mentioned, that is a critical aspect of the notice and when that needs to be delivered. The employer is required to give its notice as soon as practicable after it became aware of the event or the circumstance that gives rise to the claim. And then a notice in respect of employer's claim to extend the defects notification period will need to be provided before that period expires. And what the FEDEC requires in terms of what must be set out in the employer's notice to claim is the particulars must specify the clause or the basis of the claim, and it must include a substantiation of the amount or the extension that it requests. It must also provide documentation that substantiates the claim. The basis of the claim needs to be set out. So in other words, there needs to be a proper reference to the basis of the claim as it is entitled to claim under the contract. And then substantiation. So the claim should generally be substantiated by the relevant facts of the event that occurred, and which then as a consequence entitles the employer to claim. The FEDEC also specifically entitles the employer to a set of claims. So the employer may deduct any amounts from that money that's due or becomes due to the contractor. The employer is only entitled to settle against and make any deductions from an amount due to the contractor or to otherwise claim against the contractor in accordance with the interim payments clause. So in other words, if there's a payment due to the employer, it can set off that payment that's due to it in the following payment certificate. Examples of employers' claims. I mean, we've looked at that yesterday in terms of the risk allocation, but just to mention a few again is where the works are not completed within time, where there's remedial works that needs to be performed by the contractor in respect of any defects in the works, and then also liquidated damages that can be imposed by the contractor. The employer. Okay, then we're going to look at the contractor's claims. And that is dealt with under clause 20.1 in the FEDEC 1999. If the contractor considers himself entitled to an extension of time or additional payment, the contractor must give notice to the employer and describe the event or the circumstance that gives rise to the claim. So again, the requirements there is that the notice must give the details about the event or the circumstance that gives rise to the claim. Clause 20.1 specifically sets out a time bar provision. The notice must be given as soon as practicable and not later than 28 days after the contractor became aware or should have become aware of the event or circumstance. If the contract, and it's very specific in this regard, is that if the contractor fails to give the notice within 28 days, the time for completion shall not be extended and the contractor will not be entitled to additional payment, and the employer will be discharged from all liability in connection with that claim. So again, the importance of delivering a notice timeously cannot be overstated. Our courts held that clauses, the time barring provisions will be upheld where the notice period is clear and reasonable. The wording of clause 20.1 is intended to be a condition precedent to the contractor's claim for extension of time and additional money. Some commentators regard the fitting provision as one that will exclude the employer's liability to the contractor unless the contract first provides the notice within the time. So again, just to emphasize the importance of providing those notices within time. The English courts have taken the view that these time barring provisions in construction contracts are not mandatory but directory. It's slightly different to our court's approach. Then just like to look at became aware and should have become aware that requirement in the contract's claim provision and what that really means. So as I've said, contractor needs to notify the event as soon as it became aware or should have become aware. That means that there will be no doubt. I mean, that is quite a grey area. So there's the odds of there being an argument about when the contractor should have become aware of a particular event and the extent of the knowledge and respect of a particular event might always be open for dispute. So I'm going to give an example of that. So for example, when there are ground conditions, initially when a contractor encounters the ground conditions on project that are problematic, the contractor may decide to continue with the work in the hope that he will overcome the difficulties that it experiences as a result of the ground conditions without any delay or additional cost. But as the work then progresses, the contractor's experience of dealing with the actual ground conditions may change, and that the contractor reaches a point where he should notify the project manager that he will in fact experience a delay and may suffer additional costs. The question then arises is, should the contractor have notified the project manager at the date of the initial discovery rather than at the date when the contractor believed that the ground conditions were unsuitable? But in line with the words of FIDIC, the contractor should give the notice when he encounters the ground conditions at the time that it realizes that there is a potential impact on the progress and the potential that there might be additional costs as a result of the difficulties it may experience on the ground conditions. Again, and the reason for that is that if the notice was provided at the time when it realized that there is a potential claim, that potential risk could have been mitigated by the parties before it then resulted into an impact on the program and additional costs. Clause 20.1 also requires further notices it states that the contractor will submit any other notices required by the contract and supporting particulars for the claim as are relevant to the event or the circumstance. So you will see that although there's a reference to clause 20.1 for the contractor's claims, in particular events, there might be a requirement under that specific clause. So for example, the extension of time clause may also state that there's a requirement to give the notice. And then you would generally specify in your notice that this is not only a notice in terms of clause 20.1, but also a notice in terms of, for example, 8.4. Okay, then the next requirement under clause 20.1 is the contemporary records. It requires the contractor to keep contemporary records as necessary to substantiate the claim, either on site or at a location acceptable to the employer. Without admitting liability, the employer may, after receiving any notice under this subclause 20.1, monitor the record keeping and or instruct the contractor to keep further contemporary records. The contractor will permit the employer to inspect all records and, if instructed, submit copies to the employer. So then we'll move on, or just a note on this slide is to say that generally from our experience in disputes, the contemporary records really makes the difference as to whether your claim would succeed or not. Okay, moving on to detailed claim requirement. So clause 20.1 then further requires that a detailed within 40 days after the contractor becoming aware or when he should have become aware of the event or circumstances, will send to the employer a fully detailed claim, including full supporting particulars of the basis of the claim and of the extension of time and the additional payment claim. If the event or circumstance has a continuing effect, such fully detailed claim will be considered interim. The contractor will send further interim claims at monthly intervals, giving a cumulative delay and low amount claim. And the contractor will send a final claim within 28 days after the end of the resultant effects. So if I can just give an example of that, the interim claim is where they are adverse weather conditions, for example, that may start early in the month, but it may continue for a couple of months. And so in terms of this clause, you will submit your interim claims on a monthly basis together with all your supporting documents. And once the claim or once the adverse weather conditions end, you will give another notice with your final interim claim within 28 days after the end of that event. This clause 20.1 does not provide any time barring provision in relation to the detailed claim. So yeah, the documents just need to include the further particulars. It can also include a critical path analysis to demonstrate any delays on the program that would then entitle the contractor to an extension of the time for completion. So the delay must have a specific impact on the completion. Okay, then we can move on to the response and determination requirement under clause 20.1. There it says that the employer shall within 42 days after receiving a claim or any further supporting particulars, the employer shall respond. I'm saying the employer or the engineer, it depends on which credit you're looking at. In the silver book, it will refer to the employer. The others, obviously, the engineer. So they shall respond with approval, disapproval, and detailed comments. The employer or the engineer may also request any necessary further particulars that it may need in order to make the determination, and then respond on the principles of the claim. Clause 20.1 then continues by referencing the payments that will be included for substantiated claims. So following the determination, each interim payment must include such amounts for any claim reasonably substantiated as due. Unless and until the particulars supplied are sufficient to substantiate the whole claim, the contractor will only be entitled to payment for substantiated part of the claim. So then the employer in the civil work and engineer and the others will proceed in accordance with subclause 3.5 to agree or determine the extension of the time to completion or the additional payment to which the contractor is entitled. These requirements are in addition to those of any other subclause that may apply to a claim. So if the contractor fails to comply with any requirements in relation to any claim, any extension of time and additional payment will take account of the extent to which such failure prevented or prejudiced the proper investigation of the claim. Another important requirement is that irrespective of the claim process that may be, the parties will always be obliged to continue performance under the contract pending the outcome or the response of a determination. Okay, then we'll move on to look at specifically clause 3.5 that addresses the determinations by either the engineer or the employer itself under the Silver Book. So the clause reads as follows: whenever the conditions provide that the employer will proceed in accordance with the subclause 3.5 to agree or determine any matter, the employer will consult with both parties in an endeavor to reach agreement. If agreement is not achieved, the employer will make a fair determination in accordance with the contract, really regarding all relevant circumstances. The employer will give notice to the contractor for each agreement or determination with supporting particulars. So it's clear from the wording in this clause 3.5 that a consultation process is required and must be implemented by the engineer or the employer before it makes a determination. If the consultation process then fails, it may make a fair determination with supporting particulars. So the question then is, how do the employer or the engineer make a fair determination? The fair determination will be based on what the circumstances were at the time, and obviously with a proper assessment of the documents that were provided to substantiate a particular claim. The engineer should always have the obligations to act neutrally and unbiased. The conditions of the contract that trigger the engineer or employer's determination, there are many of them, and we've looked at them yesterday in terms of the specific risk allocations. So just to mention a few, delayed drawings, access to site, unforeseeable conditions, and failure to remedy. Most of those provisions calls for the engineer to make a determination if a claim arises. Then we will move on to look at the claims process under the FIDIC Green Book, because that is slightly different to the claims process that we've looked at under the regular and Silver Book. So in terms of the employer's claim, there's no specific provision that deals with only employer's entitlement to claim. The employer's right to specific claims are catered for under specific provisions. So it will deal, for example, with under clause 7.4 for delay damages, clause 9.1 where the employer can claim costs for remedying defects, or clause 12.4 where it may have an entitlement to termination costs. And what is interesting about the Green Book is that the employer determines its own claims. There is no agent or engineer that fulfills that function in the Green Book. Okay, then we'll move on to the contractors claims process. So the provisions that caters for contractors claim process in relation to delays or additional payments are dealt with under clause 10.3, which is the early warning notice. The early warning notice provision reads as follows. Party shall notify the other as soon as he is aware of any circumstance which may delay or disrupt the works, or which may give rise to a claim for additional payment. The contractor shall then take all reasonable steps to minimize the effects. The contractor's entitlement to extension to the time of completion or additional payment shall be limited to the time and payment which would have been due if he had given prompt notice and had taken all reasonable steps. So again, just to emphasize the importance of giving the notice to minimize the effects. And if there was a delay, that impact will definitely be considered in respect of the relief that the contractor will be entitled to. So yeah, there's definitely a requirement to provide notice for the claim. And as I said, if there's failure to give a prompt notice, then there would be consequences. The further aspect that's addressed in this clause is the obligation to mitigate. Usually the contractor will propose measures to the employer regarding mitigation proposals, and they can agree on whether these measures must be implemented. Just to give some examples of mitigatory steps that the parties can consider and agree on. If there's a delay to the project, the parties can agree on the reallocation of resources. So, for example, if there is due to an event, the parties can no longer perform a specific activity. The labor that was allocated to that activity on the project can be reallocated to perform alternative activities, and that by doing that, it should mitigate some of the delays. There can also be off-site activities, for example, that labor can be allocated to in the event that there's a delay event that causes the site not to be accessible to perform any works. Another example of mitigation strategy is a resequencing of the program. So generally, as you would know, the program is set out a certain sequence of activities that follows from one another. And if there's a particular activity that should follow from the previous activity, that could perhaps be moved to the end of the program, and then just to move, resequence the activities accordingly. Another example is acceleration. Acceleration means that there would be additional, well, it's a measure to accelerate the progress of the works by allocating additional resources to the site and work to extend the working hours, for example. And that is also a mitigation strategy that you would often find contractors to perform. Another example to mitigate the performance or the delays on the site or progress of works is to, if there's, for example, a delay in the procurement of equipment or materials, the parties can consider whether it would make sense to consider procuring that materials from an alternative supplier. It may ultimately be more expensive, but it could obviously cause that there would not be any further delays on the progress of the works. So then we'll move on to clause 10.4. 10.4 deals specifically with the right to claim. And it reads that if the contractor incurs costs as a result of any of the employer's liabilities, the contractor shall be entitled to claim to the amount of such a cost. Then it is followed by clause 10.5 that sets out the procedure. In the procedure, it says that there must be an itemized makeup of the value of the variations, and the claims must be within 28 days of the instruction or the event giving rise to the claim. The employer will check and, if it's possible, agree to the value. In the absence of an agreement, the employer will then determine the value. So yeah, and then we'll move on to specifically the clause that deals with extension of time under the Green Book, and that's clause 7.3. Your entitlement to claim extension of time is also subject to clause 10.3, which is the early warning notice. So the clause reads that subject to subclause 10.3, which is the early warning notice, the contractor shall be entitled to an extension to the time for completion if he is or will be delayed by any of the employer's liabilities. Receipt of an application from the contractor, the employer shall consider all supporting details provided by the contractor and shall extend the time for completion as appropriate. So the extension of time is, like I've said, subject to the early warning notice, which must be provided by the contractor. This is in respect of delays caused by employer's liabilities, and the employer makes the determination. Examples of contractors' claims under the Green Book is variations, change in law, design by the employer, suspension of the works, or lack of access to funds. Okay, and then we'll move on to consider the claims processes for the FIDIC 2017 suite.
Okay, so the claims process under 2017 was changed quite significantly. We now have a situation where employers and contractors' claims are dealt with in one clause, which is clause 20, instead of separately as we have in 99 versions. The procedure is also a lot lengthier and more complex, and it also includes a lot more time bars, although most of them is subject to further notices, etc., as we'll go through them. For the most part, the process under clause 20 is split in two. So firstly, you've got your, let's call them employer and contractor claims for time and money. So a contractor will have a claim for additional payment or an extension of time, and an employer will have a claim for a reduction in the contract price or an extension of the defects notification period. And then the second part of clause 20 is for any other types of claims. So claims that don't necessarily relate to money or to time. And then in terms of the aforementioned, there's three main steps, which is very similar to 99. You've got a notice, you've then got a fully detailed claim, and you've got an engineer's determination. In terms of the sub B that we've got on the slide there, the process is a lot more straightforward. The parties try to agree, and if they can't agree on the issue, then the engineer simply makes its determination. So just going into a little bit more detail of what exactly all of that now means and how it should be read. So in terms of the notice process under the new FIDIC, as you said, as the claim is for something other than time or money, and that can include things like there's an issue about certification or engineer's determination or an instruction that was given, a variation order evaluation, notices, an opinion, any of those types of things. Then the other party or the engineer is required to respond within a reasonable time of getting a notice. And if they don't respond, then it's deemed that they disagree with that. If the other party or the engineer actually sends a notice that says we disagree with the requested entitlement for relief, then a dispute is not deemed to have arisen, but rather the issue is then referred to the engineer for determination under clause 3.5, which we'll deal with a little bit later. So this type of notice for these specific other type claims shall be given as soon as reasonably practicable after the claiming party becomes aware or should have become aware of the disagreement or the issue. And the notice should include details of what the case is, as well as if there is anything, what the disagreement is from the other party or the engineer in regards to the relief suit. And as I said, it's simply a matter of the parties can't reach agreement, it just moves over to 3.5. In terms of the claims for time and money, that's regulated by clause 20.2. And so that's where we have quite an intricate process with lots of notice periods, etc. So the notice must be given to the engineer within 28 days of becoming aware, or when you ought to have become aware of the event or the circumstance giving rise to the claim. The notice must describe the event or the circumstance with particularity. And if it's not given within the 28 days, then there is sort of a time bar. But that time bar is actually subject to receiving a notice by the engineer that it was given out of time. So what the clause says is that if you don't give it within 28 days, then you lose your entitlement to claim and the notice is deemed to be or is invalid. But this is then subject to the following. If the engineer thinks that the notice was given late, he must notify the party of that fact within 14 days of receiving the notice. And he also needs to give reasons why he thinks that the notice was given late. If the engineer does not give that type of notice, then that time bar falls away and the notice is actually then deemed to be valid. So, and the other party may disagree. If there's this deemed acceptance of the notice, the other party may disagree by then giving their own notice with the details of why they disagree that there has been a deemed acceptance or deemed validation of the notice. And that will then be reviewed by the engineer. That specific issue, whether or not the notice is given in time, or whether there's some form of a justification for it, and the notice should be valid or not, that's a review that the engineer then does. If the party does receive a notice from the engineer that it had notified its claim out of time, but it actually disagrees with that, with the engineer's view, it nevertheless just continues to submit its fully detailed claim, and in that fully detailed claim, it also then details the disagreement and why it feels that the claim submission is justified. Moving then over to a fully detailed claim, what does that mean? So you've got your notice, it's either been validated or there's a disagreement, but nevertheless, you still have to give a fully detailed claim. This is a submission that must include the following things at the very least. It must detail the description or give a detailed description of the event or circumstance that gives rise to the claim. It has to have, most importantly, a statement of what your contractual or other legal basis of the claim is. It has to include all contemporary records on which that party relies. And it has to have detailed supporting particulars of the amount of additional payment, the extension of time, or in the employer's case, a reduction in the price and an extension of the DFP. It must have detailed supporting particulars of that. So it must actually include documents. This fully detailed claim must be given within 84 days, which is longer than the period that was allowed for in 1999, 42 days. So it must be given within 84 days of becoming aware, or when you ought to have become aware of the delay event. So it's not 84 days from the date of the notice, it's 84 days from the date of the event. Then there's a second time bar, which says that if within the time limit, the claiming party fails to submit the statement of the contractual or legal basis of the claim, so not the time bar is not associated with the full submission of a fully detailed claim. It relates only to the second one I mentioned, which is you have to include a statement of the contractual or other legal basis of the claim. Now, if you don't submit that within the 84 days, then your notice of claim, we're now going back to the notice, and this is now no longer your actual claim or your fully detailed claim. Your notice of claim is then deemed to have lapsed, and it shall no longer be considered as valid. So it's very important to understand that this is quite a significant change from the 99 version, because you now have to spend a little bit more time up front when you notify your detailed claim on what exactly is the basis for your claim. So once you have now submitted your fully detailed claim and the engineer sees you did not state what the contractual or other basis of your claim is, it needs to follow a similar process as it had to do under the notice provisions. So it will have 14 days to then give notice to the submitting party to say, I don't believe that you gave this statement and you're out of time. And then the same process is followed as what we just discussed in the notice provision. So you can disagree, either party can disagree, it can be, if that notice is not given, it's deemed that your detailed claim is accepted. The whole process then remains the same for the engineer's notice. We then move over to what happens after you have given your fully detailed claim. You then have an initial process of agreement with the engineer, alternatively a determination by the engineer. So once the detailed claim is issued, you look at clause 3.7. I think in the silver book it's 3.5, but in the other two it's 3.7. And that deals with what the engineer's obligations are after receiving a fully detailed claim. So firstly, the claim must be agreed or determined, even where the engineer gave a notice of time bar. So irrespective of whether he believes your notice is valid or not. And his determination or the agreement must include, very specifically, must include a statement on whether or not the notice of claim is valid. And if it was submitted late, why the late submission is justified. So in deciding this, the engineer can take account of certain things. So he can consider whether or to what extent the other party would have been prejudiced by accepting the late submission. For a late notice, any evidence, he can accept any evidence of the other party's prior knowledge of the event or circumstance giving rise to the claim. So factually, the other party knew about the event. For a late submission, the engineer can consider any evidence of the other party's prior knowledge of the contractual and or other legal basis of the claim. And then the engineer can ask for further particulars if he feels that he needs more before he can make can try to solicit an agreement or make a determination, but he must nevertheless, in any event, give a response on the contractual or other legal basis of the claim within the time limits that's set out in 3.7, and we'll discuss those now. Where claims have a continuing effect, the engineer must give a response on the contractual or other legal basis of the claim within the time limits of 3.7 after the first claim submission. And then the rest remains the same as in 1999 for claims that has a continuing effect. After receiving the notice of claim and until the claim is either agreed or determined, the engineer must include all amounts that have been reasonably substantiated as due to the claiming party in payment certificates. So he does not have to wait until the full claim is finalized. Then where the employer wants to set off any amounts that he believes is due to him, that right of set off is very specifically subject to the employer complying with these provisions. So the notice provision and giving detailed particulars, etc. So in terms of clause 3.7 or 3.5, where we now move over to the formal engineer's determination process. This clause now specifically includes upfront a provision that the engineer must act neutrally when he acts in accordance with 3.5. He does not act as an agent of the employer. He acts as an independent party. He should not be biased. So the first part, as we said, is trying to reach an agreement through consultation with the parties. This is now more widely drafted than in the 1999 version. So the consultation process must be commenced by the engineer promptly, and he must provide a record of the consultation. If agreement is reached, the engineer shall give notice of agreement within 42 days, and that is calculated differently for different scenarios. So in the case of a matter, so where the claim is not for time or money, the date of commencement of the time limit for this agreement will be as stated in the applicable subclause. So whatever the other matter relates to, you find the subclause that deals with that matter, and it's 42 days after the time limit set out in that subclause. In the case of a claim for time or costs by either party, the 42 days is after the engineer receives a fully detailed claim, or where it's got a continuing effect, 42 days after the final fully detailed claim. If agreement is reached, it must be signed by both parties. If no agreement is reached, or if the parties agree that agreement cannot be reached within the 42-day period, the engineer shall then give notice to the parties and he shall determine the issue formally. So what does the engineer's determination look like? So subject again to a 42-day period, which commences right after the consultation process is concluded, or right after the consultation process is 42 days is expired, the engineer must make his determination. In his determination, he must describe the reasons for his decision, and he must give detailed supporting particulars. If the engineer fails to give notice of either an agreement or his determination within the relevant periods, then in the case of a claim, the engineer shall be deemed to have given a determination rejecting the claim. Or in the case of another matter that doesn't relate to time or money, the matter will be deemed to be in dispute, and it will then be referred to the DAAB without having to issue a notice of dissatisfaction. The effect of an agreement or determination is that it is binding on both parties unless and until it's either corrected in terms of 3.7, and we'll talk about what that correction might look like, or it's revised in terms of the dispute resolution process. If payment is due in terms of an agreement or a determination, it must be certified immediately. And then the errors that can be rectified is typographical, clerical errors, or an error in calculation by the engineer. So where there are these errors, notice is given by the engineer, or if one of the other parties pick up the error, they will notify it. And then the engineer will, within 7 days after that, correct the error under 3.7 and reach. Okay, if either party is then dissatisfied, with the determination of the engineer, they can give a notice of dissatisfaction. And the notice of dissatisfaction must state that it is a notice of dissatisfaction with the engineer's determination. And it will also set out the reasons for the dissatisfaction. Again, very importantly, it must be given within 28 days after receiving the determination or a corrected determination. And then once that notice of dissatisfaction is given, the parties move over to the dispute resolution provisions. If no notice of dissatisfaction is given within the period of 28 days, then the determination becomes final and binding on the parties. They can no longer have it revised in terms of dispute resolution. If a dissatisfied party is dissatisfied with only a part of the engineer's determination, then that part will be clearly identified in the notice of dissatisfaction, and that part and any other parts of the determination that are affected by that part or that rely on that part for completeness will be deemed to be severable from the remainder of the determination. So that the remainder of the determination will then become final and binding on the parties in that instance. In the event that a party fails to comply with an agreement, which has become final and binding, or a determination, the other party may, without prejudice to any rights it has, so for instance, going to court for an enforcement order, it will be entitled to refer the failure itself directly to arbitration. So it can skip adjudication and it can go directly to arbitration. Okay, then in terms of the Green Book, the claims process is set out at claim 13, clause 13. And the employers and contractors claims are also both dealt with in clause 13 with the same procedure applied to both. Where the contractor or the employer has a right to claim, the claiming party has to give notice to the engineer describing the event or circumstance, and the time period for that is 28 days of becoming aware or when it should have become aware. And then the process is very similar to the red, silver, and yellow books. You've got a notice process, you have to submit a fully detailed claim, and then there's an engineer's determination. So the fully detailed claim with supporting particulars, which would include the contemporary records, has to be submitted within 56 days. So you can see that the time periods here is a little bit shorter. And then if a party fails to comply with any of these clauses, then its entitlement to relief shall take into account the extent to which the failure has prevented or prejudiced a proper investigation of the claim and or mitigation of the effects of the claim. So there's no specific time bar. The engineer can just, for instance, reduce the claim amount or the time if it feels that mitigation would have been possible had it been notified earlier. Then in terms of the determinations clause, there's a new subclause 3.5, which was not there previously, which deals with the engineer's determination. And it's just a simple clause that says that when the engineer is required to agree or determine the matter, any matter, then he will act neutrally. He will not be deemed to act for the employer. He will consult to try and reach an agreement with the parties. And if that's not possible, then he'll make a fair determination. Specifically, the engineer again has got a time limit. He has to give his determination with supporting particulars within 42 days from receiving the actual claim. Okay, then the NEC claim process is quite complicated. So it's just, I'm going to just take you through kind of the process in terms of the actual NEC3. So there is provision for an early warning to be provided, and that's under clause 16. And then your claim provisions really start at, or it is included in clause 6, and it starts with a very specific closed list of what a compensation event might be. So in terms of NEC, we talk about compensation events or CEs, and you'll find them under clause 60.1. And these are literally all of the events or circumstances for which contractor might be able to claim. So if something happens and it's not in that list, then it's not a compensation event, i.e. you can't claim time or money. But it is a very comprehensive list. And so I must just caution that just because something is listed as being a compensation event, does not mean that there is necessarily a time and cost related consequence to the compensation event. So we start with the notice provisions, which is set out in clauses 60 or in clause 61. So there's a very specific split between compensation events which arise from a project manager or a supervisor giving an instruction or changing an earlier decision versus a compensation event that arises because of something else for which the contractor is not responsible. So for a CE which arises from a project manager's instruction or a change to an earlier decision, the project manager is actually required to notify the contractor of the CE, and it needs to notify that at the time of giving the instruction or at the time of changing the earlier decision. Simultaneously, he then instructs the contractor to submit what is called a quotation in terms of the NEC. So that we'll talk about that in a bit. And that is unless the event arises from a fault of the contractor. If the event arises from a fault of the contractor, the project manager nevertheless notifies the CE, but he doesn't have to instruct a quotation because there's no anticipation of having to pay the contractor or to give him any time. Okay, and then After a quotation is submitted by the contractor, he puts the instruction or the change decision into effect. For any other event, the contractor has to notify the project manager of a compensation event. He can also notify the project manager of a compensation event where the project manager has failed to notify the contractor in terms of what we just discussed. If the contractor, however, does not give this notice within 8 weeks of becoming aware of the event, he won't be entitled to a change in the prices or the completion date. So it's a time bar, he loses his claim. The only caveat to that is unless the project manager should have notified the event. So if it's an event that the project manager should have notified, then there's no time bar. The contractor can notify it, hopefully within a reasonable period after the project manager failed to do so, and he can still claim even if it's outside of the 8 weeks. Okay, then once there's a notice, the project manager needs to decide whether he needs to decide 4 key things. Whether the event arises from a fault of the contractor, whether the event has not happened or is not expected to happen, whether the event has an effect on cost and completion, and whether the event is something that is not a compensation event in terms of 60.1. If he believes that the event that was notified is one of those 4 things, he then notifies the contractor of his decision that there will not be a change in price and there will not be a change in the completion date, i.e. the claim fails. If the project manager decides otherwise, so he decides there is a valid compensation event, he also notifies the contractor accordingly, and he then instructs the contractor to submit a quotation for that compensation. If the project manager does not notify his decision to the contractor within a week of the contractor's initial notification of a CE, then the contractor may notify the project manager of this failure, and the project manager is then given a further 2 weeks to reply. And if he still does not reply within the further 2 weeks, then it is treated, or the contractor's notification of a CE is treated as being accepted by the project manager. So there's a deemed acceptance of the claim. This does not yet relate to an acceptance of time or cost consequences. It just means there's a deemed acceptance that the event is a compensation event. And the contractor can then provide the quotation for that event. If the project manager decides that the effects of a CE are too uncertain to be forecast reasonably, he can make assumptions about the event, and he can ask the contractor to submit quotations based on those assumptions. And if any of them is later found to have been wrong, then the project manager will notify correction to that. And then a compensation event critically cannot be notified after the defect date. So there is a cutoff period. Okay. Moving on, then okay, so I see all the slides are in the right place. Moving on to what is a quotation then, which is set out in clause 62. So after discussing with the contractor different ways of dealing with a compensation event which is practicable, the project manager can instruct the contractor to submit alternative quotations. So you can see it's very much a collaborative approach in terms of NEC. The project manager and the contractor talks all the time It's not a case of submitting your claim and it gets determined. It's a case of submitting a claim, talking about it, see, can we reduce costs, can we reduce time, submitting quotations, and for the project manager to then make an informed decision as to what needs to happen. So the contractor then submits the quotations to the project manager, and he can submit other methods of dealing with the CE that he thinks might be practicable. So what the quotation is it sets out what the proposed change to the prices is and what the delay to the completion date is. So the contractor basically submits the details of his assessment, his own assessment, with each quotation of what the additional cost and time might be. And if the program for the work is altered by the CE, then the contractor needs to include changes to the program as well in his quotation. He has to submit his quotations within 3 weeks of being instructed to do so by the project manager, and the project manager has to reply within 2 weeks after that submission. And the project manager's reply can be one of four things. His reply is an instruction to submit a revised quotation, or he accepts the quotation, or a notification that a proposed instruction will not be given, or a proposed change decision will not be made, so a rejection of the quotation and the CE, or a notification that he will be making his own assessment. And we'll talk about when he can do that. So he's not happy with the assessment that the contractor has made, and in certain circumstances, he can then make his own assessment. So the project manager instructs the contractor to submit a revised quotation only after explaining his reasons for doing so to the contractor. And again, the contractor has 3 weeks to submit a revised quotation. And then if the project manager does not reply to a quotation within the time that's allowed, then the contractor notifies the project manager of that failure. He then again has another 2 weeks to reply. And if he doesn't do that, then the contractor's notification is treated as acceptance of the quotation by the project manager. So here you have your second deemed acceptance, and this is now deemed acceptance of what the contractor's assessment was as set out in his quotation. Right, then moving on to an assessment of CEs, which is done by the project manager in terms of clause 63. So the changes to the prices are assessed as the effect that the CE might have on 3 things. Firstly, the actual costs of work that was already done. Secondly, the forecast cost of work that has not yet been done. And thirdly, on a fee. So the date when the project manager instructed or should have instructed the contractors to submit quotations divides the date for work already done versus work not yet done. So what that means is a portion of the quotation or the claim will be based on actual costs, and a portion of it will be based on forecasted costs or estimated costs. And everything up to the date of when the project manager gave an instruction for a quote or ought to have given that instruction, everything up to that date must be based on actual costs, and everything after that date can be forecasted or estimated. Okay, and then a delay to the completion date is assessed as the length of time that, due to the CE, the planned completion is now later than what is shown in the accepted program. If the project manager has notified the contractor of his decision that the contractor did not give an early warning in terms of clause 16 of a compensation event, which he believes an experienced contractor could have given, the event is then assessed as if the contractor had actually given the early warning. So you can see the early warning is really just a project management tool, and it's not really there to affect the claim process. Okay, and then a compensation event, which is an instruction to change works information in order to resolve inconsistencies or ambiguities, will have to be assessed as if the prices and the completion date were for the interpretation most favorable to the party who did not provide the works information. So typically the works information would be given by the employer, and so these types of CEs are interpreted in favor of the contractor when they are assessed. Okay, then moving on to clause 64, which is the project manager's assessment, final assessment of the CE. If the contractor, so this is, sorry, let me just clarify. This is where the project manager can make his own assessment. So we talked about the quotations being assessment by the contractor, and in some circumstances, the project manager can make an assessment. So 64 is that, it's the project manager's own assessment. And he can do that in 4 circumstances. If the contractor has submitted a quotation, and details of his assessment within the time allowed, then the project manager will assess the compensation event in terms of that. Or if the project manager decides that the contractor has not assessed the compensation event correctly in his quotation, and he does not instruct the contractor to submit a revised quotation, then he can make his own assessment. If, when the contractor submits the quotation for a CE, he has not submitted a program which shows amendments as required, then the project manager may make his own assessment in terms of the time. And if, when the contractor submits his quotation for a CE, the project manager has not accepted the contractor's latest program for reasons stated in the contract, and we won't go through those now, but if he does not accept the latest program submitted by the contractor, he may also make his own assessment. So the project manager notifies the contractor of his assessment of the CE. He gives him the details of it. And well, it gives him the details of it within the period allowed for the contractor's submission of his quotation for the same event. So that's typically your 3 weeks, sorry. If the project manager does not assess the CE within the time allowed, then the contractor can notify the project manager that he's failed to do that. And if the project manager then fails to reply within 2 weeks after that notice, then the notification is treated as acceptance of the contractor's quotation. So here you have third deemed acceptance, where you're now actually going to be implementing a quotation. And so if the project manager doesn't respond as it should, basically your claim is deemed accepted and must be paid, or the time must be given. And that then moves or takes us to the last part, which is clause 65, where now the CE has to be implemented. You've given your notice, you've had this collaborative discussions around the quotations, and an assessment has been made, or there's deemed acceptance, now it needs to be implemented. So compensation is implemented when the project manager notifies his acceptance of a quotation, or he notifies his own assessment of a CE, or a contractor's quotation is treated as having been accepted, so deemed acceptance by the project manager. All right, and that is it. So you can see it's quite a complex process for claims in terms of the NEC. And even if you just read the clauses, it doesn't always make sense. So the NEC is really a kind of a beast on its own, but I hope this was helpful to some extent at least. Just quickly looking at how the claims process under the NEC 4 is different. There's really not much. There's just 2 specific compensation events that have been added. And that's that the contractor may recover the costs of preparing a quote for a proposed instruction, and agreed compensation events can be inserted into the contract data. And then they clarified the dividing date for the purposes of a CE. So if the CE arose from communication from the project manager, then the dividing date is the date of that communication. And for all other compensation events, the dividing date is the date when the CE was heard. And that is it for NEC.
Okay, so now we'll move on to look at the claim process under the new JBCC Principal Building Agreement, the 2018 edition. So in this contract, the contractor's claims is not dealt with in one specific clause, but in one of 2 clauses. So we'll quickly look at those provisions. Firstly, we'll look at the contractor's claim for expense and loss, and that is dealt with in clause 26.5. That entitles the contractor to claim expense and loss that is not already provided or catered for in the contract sum. So in terms of the structure of the claim for expense of loss, there are 3 steps that needs to follow to proceed with a claim for expense and loss. And that is firstly to ensure that there is an entitlement claim. Secondly, to calculate the actual expense and loss. And then thirdly, to provide supporting evidence and documentation. So the 4 conditions that are present in terms of ensuring that you have the entitlement claim is: 1 must consider the contract sum provisions and ensure that such a loss and expense has not already been included in the contract sum or provided for in the contract sum. Secondly, there shouldn't be any double compensation for the same expense. So if the contractor already relied on a different clause in the contract that entitled it to the same relief, it cannot have the same relief again in respect of a different clause. Thirdly, the contractor needs to adhere to the notification periods. The contractor must notify the principal agent about the expense and loss within 40 working days from when it became aware or when it should have reasonably become aware of the expense and loss. And then fourthly, there mustn't be any fault on the contractor side. So the expense and loss should arise as a result or should not be attributable to any fault by the contractor. So then when calculating the actual loss and expense that was started by the contractor can only claim the cost that it can properly demonstrate and that it factually incurred. And the onus is on the contractor to prove that it actually suffered the expense and loss, which would be demonstrated by way of contemporaneous documentation, as we've discussed earlier on, such as invoices, bank statements, etc. Then the claims process for adjusting the contract value is also addressed in clause 26.5, the expense and loss. The contractor shall give notice to the principal agent within 20 working days of becoming aware or reasonably to have become aware of the expense and loss, for which provision was not required in the contract sum. Failing which, so again, if there's no notice, failing which such claim shall be forfeited. Following the notice, the contractor shall submit a detailed and substantiated claim for the adjustment to the contract value to the principal agent within 40 working days, or such additional period as the principal agent may allow. The principal agent shall then consider and assess the claim and make a fair assessment of the claim and adjust the contract value within 20 working days of receipt of the details of that claim. If the principal agent again fails to act, then the claim shall be deemed to be refused. And the contractor may in that circumstances give a notice of disagreement of the claim. Okay, then I'll move on to consider the contractor's claim in respect of extension of time. That is dealt with under clause 23. The 3 steps that needs to be considered in terms of the structure of the contract is, again, to ensure that there's an entitlement. Secondly, to quantify the claim, and thirdly, to provide the additional corroborating evidence and contemporaneous documents to support the claim. The extension of time to the practical completion date entitlement is set out in clause 23.1, where it lists the events that entitles the contractor to a revision of the practical completion date without an adjustment to the contract value. So the way it is structured, that there are 3 scenarios where you can claim extension of time to the practical completion date. One is with an adjustment to the contract value, without an adjustment to the contract value, or where there is an adjustment to the contract value, but in that circumstances, the event should have been beyond the control of the reasonable control of the contractor, and for which the contractor couldn't have reasonably provided for. So we'll firstly look at the events that entitles the contractor to a revision of the practical completion date without an adjustment to the contract value. So those are circumstances that are typically beyond the party's control, and where the consequences are then shared between the parties. That's adverse weather conditions, the inability to obtain materials and goods, where the contractor has taken reasonable steps to avoid or reduce the delay, making good physical loss and repairing damage to the works, late supply of a prime cost amount item where the contractor has taken reasonable steps to avoid or reduce the delay, force majeure, where there's an exercise of statutory power by a body of state or public or local authority that directly affects the execution of the works. So that can be, for example, where the State Department delays the issuing of particular consents or permits that's necessary. In clause 23.2, we are dealing with where the contract is entitled to an extension of the practical completion date with an adjustment to the contract value. In these circumstances, the contractor will be relieved from any imposition of penalties by the employer. So the circumstances that you will face here are events such as delayed possession of the site, contract instructions that's not occasioned by the contractor's default, making good physical loss and repairing damage to the works where the contractor is not at risk, late or incorrect issue of construction information, late supply of free issue materials, act or omissions by the nominated subcontractor or a direct contractor, etc. There's a long list that you can consider at your own time. And then, as I've said, clause 23.3 deals with the circumstances that entitles the contractor to a revision of the practical completion date and an adjustment of the contract value, but where it's due to an event that must be beyond the contractor's reasonable control, and for which the contractor could not have reasonably provided for or anticipated. Okay, then moving on to consider your entitlement or to ensure that you've got an entitlement to claim is firstly the notification. So once the circumstance that we've just looked at occurred, the contractor must take reasonable steps to avoid or reduce the delay. And then within 20 working days of becoming aware of the event, or when it should have become aware of the event, it must give notice to the principal agent of the intention to submit an extension of time frame. If it fails to deliver the notice and submit it within the 20 working days, that will result in a forfeiture of the contractor's claim. Then the next step is to submit the contractor's claim. The contractor must submit a claim for the practical completion date extension within 40 working days from when the contractor is able to quantify the delay in terms of the program. The principal agent may allow an extended period within which the contractor may submit such a claim. Then just to look at when you submit the claim, there are obviously certain requirements that needs to be complied with in order to submit a proper claim, and that is there must be references to the clause that the contractor relies on for its entitlement to claim. The cause and the effect of the delay on the current date of practical completion must be properly illustrated by a change to the critical path, and that will be demonstrated with support and reference to the facts of the particular event that occurred. The extension period claimed in working days and the calculation thereof must also be included in your claim. Again, and we've touched on this, is the best evidence to substantiate an extension of time claim is contemporaneous documentation, which is updated programs that illustrates the critical delay to the practical completion date, site diaries are signed off or checked by an independent party, delivery notes, contract instructions, emails, and minutes of meetings. Then once the claim is submitted, we'll consider the determination process that's dealt with under clause 23.7. The principal agent is obliged to make a determination within 20 working days of its receipt of the claim, and its determination can either be when grants the claim in full, reduce the claim, or refuse the claim as a whole. When it submits its determination, it needs to substantiate the determination of the revised date for practical completion. It must identify the event and the reference of the clause for each revision that's granted or amended, and provide reasons if the claim is refused. Then there is no specific, if we move on to employers' claims, just to mention that there is no specific provision or clause that deals with employers' claims, but the employer also has a right similar to the contractor to claim expense and loss. And an example of that would be if there's any defective works that needs to be remedied. The way that it's dealt with in the principal building agreement is by way of a recovery statement. So the principal agent shall issue a recovery statement, as we briefly discussed yesterday, with each payment certificate, with explanatory documentation to support the calculation of the amounts that's due to the employer for expense and loss. The amounts that's due to the employer can result from penalties where there's default interest on payments that's due to the employer, and then, as I've said, expense and loss. Amounts, just to deal with the recovery statement by itself, amounts that's due to the contractor that's reflected in the recovery statement can result also from default interest based on payments that's due to the contractor, compensatory interest, damages, expense and loss caused by direct contractors, any advance payments that's due to the contractor, termination payments, etc. The employer may recover expense and loss that it incurred that results from paying charges, affecting insurances due to the contractor's default, work that's executed by others due to the contractor's default, recoupment of any advance payments that were made to the contractor, all of those, just to give a few examples. Where an amount is due to either party, the contractor or the employer, and has not been paid, the other party may recover the amount from the subsequent payment certificates, which will then attach the recovery statement. A demand in terms of the security, which is a performance bond or advance payment bond, or just as a debt in the general sense. Where either party has been liquidated or the agreement is terminated, the other party may exercise its rights in terms of security. That's also just a remedy that's available to the parties. Then where the principal agent fails to act within the specified period, a claim will be deemed to be refused. The contractor may provide a notice of disagreement where the principal agent refuses or reduces the claim, and further disputes regarding the determination or extension of time claim will be handled then under the dispute resolution provisions in clause 13, and we will discuss that later on in the session.
So, starting with the alternative dispute resolution, we are first going to look at a general overview of the processes that's available to us. So, alternative dispute resolution is basically an alternative to court litigation. And so there are various methods that can be used. The first thing is amicable settlement. The second thing is mediation. You can also use employers' representative determinations, or you can use expert determinations. And those all are processes that are very flexible and somewhat informal. And then with more formal approach, you can use adjudication or arbitration. So I'm just going to go through each of those with you, just explain to you very briefly what they are, what they entail, and then we'll look at what the advantages and disadvantages are of using any form of alternative dispute resolution. Okay, so amicable settlement is a process where issues are settled with the help of either an independent and impartial party or between the parties themselves at a more senior level or a combination of the two. And so typically what you would find here is you would have either normal negotiations, you would have a conciliation process or an executive panel negotiation. So a negotiation, I think everyone is familiar, is basically a compromise to settle an issue so that both parties benefit as much as possible. So the aim is a win-win situation where honesty and transparency is very important. It's not merits-based, it's more of a commercial-based discussion. Conciliation is where a conciliator meets with each party separately and jointly in order to resolve issues. And this is very much similar to a mediation process. And it's very important to understand that the conciliation process in and of itself has no legal standing. So the conciliator usually has no authority to seek evidence or call witnesses. He doesn't write a decision, he doesn't make an award. He's just there to facilitate basically the negotiations. An executive panel is kind of a mini trial, and it's more suitable for complex issues where the parties wish to maintain an amicable relationship. So each party will appoint a senior executive with authority to make binding decisions, and a representative to act on their behalf, as well as expert advisors, if they deem that necessary. And the parties can then also jointly select an independent or impartial, partial, neutral party who then controls or manages the proceedings. And so prior to this mini trial that happens, the parties exchange information that they want to raise. They make representations during the process, which can be factual or expert-based. And they're then allowed to ask each other questions. The senior executives will hear and be able to evaluate the strengths and the weaknesses of their respective positions. And hopefully this then motivates them to try and settle the matter amicably. So on conclusion of the process, the executives should endeavour firstly to resolve the issues themselves. And if not, then they move over to a more formal process. Mediation is informal, again, a neutral third party who proposes compromise settlements between parties. The mediator gives an opinion, and this opinion is not final or binding unless an agreement is concluded and the parties sign that agreement. The function of the mediator is to resolve an issue by bringing the parties to an agreement that's acceptable to both of them. In achieving this, it helps if the mediator is able to critically point out the weaknesses in the positions of the parties, and give him some form of a reality testing. And also, a good mediator will be able to generate alternative solutions to the parties which might be more comfortable. So it is useful, although not essential, that the mediator is an expert within the area that you find the disagreement on. It's important that the mediation takes place in the context of a formal agreement to mediate, setting out the powers and the duties of the mediator. But mediation does not establish legal rights for parties. It's a compromise-based approach, and therefore, often lawyers will not be permitted to be present, although they can be sitting outside or be on standby just to give some guidance to their clients. As I say, it's not supposed to be a merit-based process, but more compromise. And then the mediator must just try to establish jointly or separately with the parties common ground, create flexible and alternative solutions. And in order for a mediator to be able to do that, the parties must take the mediator into their confidence. The mediator will have separate conversations with the parties, and those conversations cannot be divulged to the other party. It's confidential. And then there'll be joint discussions as well. So this obviously hopefully allows the mediator to understand the bigger picture from both parties' side and to try and persuade parties to make certain compromises. Okay, then a determination by an employer's representative is exactly the types of stuff that we spoke about in the FIDIC, JPCC, and NEC. And I'm not going to go through those again, but for the most part, the standard contracts all have that as kind of a first tier dispute resolution method, where the engineer or the PM or the PA makes a determination of the claim as in the first instance. Then we also have expert determination. This is not often used, but it is used in certain contracts quite often. So this is where an expert is called to give an independent and an impartial determination of an issue that is of a more technical or very specific nature. It's not often it should not be used for a wide range of things. And so if you have an issue that is technical, let's say in engineering, then you would have an engineering expert. If there's an issue with programming, you would have a delay analyst or a programmer. If it's related to quantification or certification or anything financial, you have a financial expert. So the expert's main task is to make a determination on a specific issue within that he has specific expertise on, and it's on the basis of information that he receives from the parties. It's completely submission based. So the most important part of the expert determination process is that you very carefully select your expert. So it doesn't help you appoint an expert to determine a certain matter on which they really don't have the expertise or the desired qualifications. Then moving over to adjudication, which is generally a first tier dispute resolution process, with arbitration being the final process. In adjudication, there's two options that can be followed. You can either have an ad hoc adjudication or a standing adjudication. A standing adjudication is the preferred choice for bigger and more complicated contracts, especially if they are going to run over a long period of time. It's not appointed to deal with disputes only as and when the disputes are declared. It's rather a board or a single adjudicator or a board appointed to, throughout the project, be proactive in dealing with the parties and endeavoring to prevent issues which might lead to claims or which might become disputes, and to encourage parties to take steps to avoid something becoming a claim or a dispute. So the advantages is that your panel or your adjudicator is usually experienced, they are impartial to both parties, so they're independent, and they can be trusted to establish the right environment on the project to deal with complex problems and claims that can be freely discussed before they escalate into disputes. So what the standing board or the standing adjudicator does is they act on a continuous basis, and they are available to the parties throughout the process. And because of this, they remain informed of what's happening on site, what's the progress of the works, what's the progress of claims that have been submitted, what problems are popping up, and they can then properly assist the parties to find solutions to these issues, find ways in which to deal with claims that's beneficial to both parties. So in the presence of a standing adjudication, the parties are inclined to focus on the business rather than spend their time on misunderstandings and disputes, etc. So it promotes a more positive frame of mind for the parties. So the standing adjudication board or the adjudicator is not allowed to talk to parties separately. It can give opinions when they are asked jointly by the parties to do so. And if it gives an opinion, it should always bear in mind that there may be additional facts that may influence that opinion. So they can ask for more information as well. An ad hoc adjudication, also a single adjudicator or a board of adjudicators, is where they are appointed as and when a dispute arises, and they are appointed for a very specific dispute or specific disputes. The advantages of having an ad hoc adjudication is that as a decision should preferably be reached without having a formal hearing, the ad hoc adjudication can be relatively inexpensive. It can be composed to suit the dispute in question. Again, you get to choose your adjudicator every time a dispute arises. You get to choose a new one. And so if the dispute is, for instance, mainly about a legal interpretation of the contract, you might want a legal expert, whereas if it's more a technical issue, you might want a technical expert to act as an adjudicator. The disadvantages of an adjudication is that, or an ad hoc adjudication, is that adjudications are meant to be a quick and dirty solution, and that might not always come or have a fair decision attached to it, or even where the decision is fair, not necessarily always the right decision. It should be done within very tight timelines, usually, because it's supposed to be rough justice, which some parties don't always appreciate or like. And there's not going to be a hearing just because of how an adjudication should be run. And so parties don't have the full ambit of an arbitration, for instance, available to it to set out everything that it might want to. So I'm calling those the disadvantages of an ad hoc adjudication, although those are exactly the things that an adjudication is supposed to do in order for parties to get on with business and get an interim decision which could promote cash flow for the contractor, for instance. Then we've now also got a dispute avoidance board or adjudicator mechanism, dispute avoidance mechanism in place under FIDIC 2017 and NEC 4. And we'll deal with that in detail a little bit later on. Okay, so for now, let's talk about just adjudication generally. What is the process? What should it look like? How should you be running an adjudication? So it's an accelerated and a cost-effective form of dispute resolution that results in an outcome that is a decision by a third party and that is binding on the parties. So it's not necessarily final, but it is binding. So it's supposed to be speedy because a decision in most instances can be given in 28 days or 42 days. Those are typically the periods that some of the contracts have. The period can be extended, of course, with consent between the parties, because adjudication is all about agreement between the parties, and they are the leaders of the process. It can be relatively cheap because it does not include cost orders, or should not include cost orders. The fees of the adjudicator is split between the two parties. And then the adjudicator can be named in the contract, although, as I said, if you appoint an ad hoc adjudicator, at that stage you know what the dispute is about, and you're probably in a better position to appoint a suitable adjudicator. So what some parties do is, instead of nominating an adjudicator in the contract, they nominate a list of adjudicators that both of them agree would be suitable, and as and when a dispute arises, they choose then one from the list. An adjudicator takes the initiative to ascertain facts and law He's not bound by litigation or the formalities of litigation. He doesn't have to grant extensions. Generally, you have a timetable that's agreed up front, and the parties need to submit in accordance with that timetable. And he then has a certain period to give his award. As I said, it's not practice to have a formal hearing in adjudications. We do see a lot of adjudicators asking for hearings, which just makes the process costly and just takes longer to resolve. So it's not ideal to have a hearing in an adjudication. It's supposed to be an interim resolution to the parties' disputes, which they can implement, be bound by while they focus on the project. And the reason it can be sufficiently used as an interim method is because you always have arbitration if you're really unhappy with that decision. So the main principle is a rough and ready justice. And that means the adjudicator doesn't have to have all of the information and all of the testimony and expert reports and a whole mini arbitration running just to make a decision. He looks at the party submissions, which is generally just one set of submissions, and he then gives a fair and equitable award. If a party is then dissatisfied with this award, it can always go to arbitration, which will then be the final recourse as a second tier. So if used correctly, adjudication can be a very powerful tool. It can also be a very powerful project management tool. It's quick, it's efficient, it's cost effective, and it helps keep the parties' relationship intact. However, if it's not used in the manner that it's supposed to be used, it can have the opposite effect. And it's therefore important that firstly, you appoint the right adjudicator who will take control of the process and who will ensure that this rough and ready approach is taken rather than having a protracted and a costly process that's more akin to an arbitration. The adjudication is really supposed to be aimed at parties and what would be in the best interest of parties as well as the project. It's not aimed at getting a court judgment. And just, by the way, an adjudicator's decision cannot be reviewed. So it isn't supposed to be a court judgment. So in South Africa, adjudication can only be used where the parties specifically agreed in writing that it must be used. And the parties must very specifically set out what the ambit is of the dispute that they are referring to the adjudicator. Common law does not apply to adjudication in courts. It does not apply to adjudication. So the courts will not readily imply terms into an adjudication contract or an agreement unless that implication is very clear. It's a creature of contract in terms of which the parties make the decision to confer jurisdiction on the adjudicator for deciding a very particular dispute that arose between them. The adjudicator's decision is binding. It's enforceable, even if the parties are dissatisfied with it and refers it to arbitration, it remains enforceable. So there's many cases on this, and case law is clear that the adjudicator's decision should be enforced as binding on the parties, even in the case where the parties anticipate or have notified that they want to refer the dispute to arbitration. And then the adjudicator's award is capable of becoming final. So if the dispute is not referred to arbitration by either party, and usually the contracts have specific time periods within which you need to do that, then the award will be final as well as binding. Then, although the standard forms call for adjudication, many bespoke contracts still do not include adjudication in South Africa. It's not used outside of the construction industry, it's not used that much. And within the construction industry, even in South Africa, it's not used efficiently and effectively, and it's not having, you're not getting the benefits out of adjudication as we should. So there has been a big drive in South Africa within the legal fraternity to change this, to get good adjudicators trained, and to ensure that at some stage we get some legislation on adjudication in South Africa, in order for us to reap the benefits of a quicker process in arbitration. Okay, then arbitration, that's just your final process or final alternative dispute resolution process, and an arbitrator's award is final and is legally binding. It's subject to the Arbitration Act of 1965 for certain arbitrations that have been started before the new act came into place, and the current applicable act is the International Arbitration Act of 2017, which is basically an incorporation of the model law on international commercial arbitration rules, as has been adopted by the United Nations Commission on International Trade and Law, or as we all know, it's conceptual. And so the most outstanding characteristic of an arbitration is that it's a final process, so it's very much has the effect of court litigation, but it is supposed to be a lot quicker. You get to choose your arbitrator, again, choosing someone with relevant experience in the dispute that you have. You get a chance to have a proper hearing with examination and cross-examination, and the parties can do it within their timelines, which is no doubt a lot quicker than the courts. And then the arbitrator's award can be made in all of court as well, if necessary, and that can be enforced, obviously. So the advantages of arbitration is that a trained arbitrator with experience in the relevant areas where the dispute is can hear the matter, which is something that you don't get in court, obviously, or always necessarily. It's a lot quicker, and unless the party specifically agreed to it, there's no appeal process. So it's final and binding. It's private and confidential, so parties' dirty washing is not hanged outside, and it will no doubt be, although it's still very expensive, probably less expensive than a court litigation matter. Okay, and then in terms of the sources of law for arbitration, we have a lot of common law on arbitrations in South Africa. We've got the Constitution, we've got the two arbitration acts, the ancestral model law, we've got the Convention on Recognition and Enforcement of Foreign Arbitral Awards, and then you will have, as part of that, your arbitration agreement, which is the main document in terms of which the arbitration process will be conducted. All right, so just looking quickly at the key differences between these methods. So mediation is not binding unless there is an agreement concluded and it gets signed. Adjudication is quick and dirty, relatively cheap. It's based on submissions only, but it's interim. Arbitrations can be quite expensive. There's often witnesses and expert reports. It's time consuming in South Africa, specifically because councils typically sit as arbitrators and they have full diaries together with legal teams having full diaries, and hearings can often extend into long periods. It does require a lot of focus and effort from the project personnel. They have to be very involved in this process in order to give evidence. They'll have to give testimony, and so it takes a lot of resources away from the parties. It's more formal and legalistic. It's quasi-judicial, and then it's final and binding. In expert determination, it's very limited because only certain types of disputes are referred to expert determination. A determination by an employer's agent, although it should be an independent decision, it's not always independent. And a dispute might involve complex legal arguments, which the employer's agent doesn't have expertise on. Okay. Then just looking generally at the advantages of alternative dispute resolution. It does allow parties to avoid hostility, or it should, if it's used correctly. It generally is cheaper than litigation. It definitely is faster than litigation. It's a lot more flexible, and the parties get to choose a lot of how the matter is conducted and who's part of that. It has simplified rules of evidence and procedure. So there are certain rules, and the parties choose which set of rules they want to use for their arbitrations. And most of those rules are at most 10 pages long, so it's really a very simplified process, and it's private. The disadvantages is there's not really any rules of evidence. Together with that, it doesn't create any precedents for other arbitrators to use. So you're kind of reinventing the wheel every time with each arbitrator making their own decisions in terms of what evidence can be given. And although our case law court judgments must be taken into consideration by arbitrators, a lot of the disputes that we see in construction arbitrations are disputes that never come before the courts. And so there's a real lack of precedence on a lot of these issues. And that also creates the issue of various arbitrators with differing opinions making different decisions on exactly the same issues in the same contracts. So some ADR processes have a lack of cross-examination. Arbitration is the only one where you can really cross-examine your witnesses. As I said, there's a lack of consistency. It really depends on who your presiding officer is and what their views in life are as to what your outcome would be. There is a lack of evidence in some of these cases. You don't present everything you have and go through a proper assessment of evidence. And again, it's not public. So although it's a benefit that it's private, sometimes it's a disadvantage because there's a lack of transparency. And often where you have, for instance, government entities being counterparties, you do want there to be, you don't necessarily want it to be a private matter because you want them to take some responsibility for how these projects are managed. Okay, then dispute avoidance. So yesterday we've touched on the main causes of disputes. And specifically in South Africa, I've just mentioned a few there again. So restrictions to access to site or late access to site is actually one of the leading causes of disputes in Africa. And this is obviously an issue that impacts on the whole project and all subcontractors. And there's no real way for a contractor to mitigate delays that's caused by access to site. So where contractor is responsible for off-site work as well, like design or manufacture, this can become an issue in a dispute where you claim today for lack of access, because there might be an argument that some of those off-site work could be done in the meantime, or where your off-site work is late, there might be an argument that you didn't need the site access because you were late in any event with some of your off-site work that was required before you could go on site. So an employer can argue that restrictive access was always anticipated as well if there's more than one contractor working on the site. And interfacing problems come up almost always with these types of projects where there's a lot of contractors on the site. So most of the standard form contracts do allow for this obligation, or for an obligation on the contractor to work together with others while in the same area. Although it doesn't always solve the issues that come with that. And then incomplete or poorly drafted or unsubstantiated claims, we see that almost always in all of our matters. So there's two, and globally, this is a real problem as well in disputes. There's two main issues that contribute to incomplete or unsubstantiated claims. The first is that the parties do not keep their necessary records that they should throughout the project. They don't have proper document management software, or they don't use it correctly. And the second thing is that by the time the matter gets to alternative dispute resolution, there's just no witnesses left because parties have left so long. There's a real loss of evidence and witnesses. So the standard form contract set out the particulars required for substantiating claims, as we've discussed, albeit that it doesn't always set out all the details that you would require if those claims ultimately go to dispute resolution. In terms of quantifying claims, in most instances, the preferred method of calculating the costs is based on actual costs. And so it's very important that the party who claims submit the necessary invoices, payment, contracts, proofs of payment, all those things, because often the dispute really goes all the way to ADR because the party who's supposed to accept the claim just doesn't have sufficient information, and the party who makes the claim just doesn't want to provide it. Okay, so having a proper, effective, and useful project schedule is almost the most important thing that you need to have on your project, because without that, you can never really show your delays and justify your delays. And so it's very important when making your claims that you are able to substantiate the actual delay that you are claiming. Another issue is poorly drafted contracts, and we see that specifically within the government sector in South Africa. So globally, this is the second largest pool of disputes. Errors and omissions of contract documents. Unfortunately, it often happens that a commercial team negotiates a contract, and then there's a separate project management team that has to implement this contract, but they didn't give any input into the terms of that contract. They might not even be familiar with that type of contract. We also often see copy and paste jobs where the terms just do not make sense when you read them together. There's many gaps left by the drafting. So poorly drafted contracts create uncertainty between the parties, and often the parties have to spend days on legal arguments over proper interpretation of a particular clause that's poorly drafted before getting to the merits of the matter. Outdated contracts being used is also an issue where it just doesn't fit the market anymore. we chatted yesterday about making too many amendments to standard form contracts, leaving gaps and issues and creating unenforceability issues. And then sometimes it is a matter that the contractor or the subcontractor has limited negotiation skills, or they have limited power to negotiate, which is an imbalance, creates an imbalance in risk between the employer and the contractor. We also see that there is generally a lack of understanding of risk allocation, and so parties think that they are not liable for something or should be doing something in terms of the contract when in fact they should be. And it takes them through a whole alternative dispute resolution process to realize that they had not properly understood their contracts. All right, then you've got variation orders by owners and employers. Also one of the main issues, because there's almost always a debate between the parties, an argument between the parties on whether the variation order was given because of something that the contractor did or did not do and should have, or whether it's a real change by the employer. And this again goes into or forms part of really knowing your contract and properly setting up your technical requirements and understanding your scope of work. Because often variation orders are given within a scope of work without a contractor really understanding that, or from the start understanding that that was supposed to be part of the scope of work. As of late, obviously, we see a lot of financial distress because of payment issues, because of poor determination of claims, delays in determination of claims, or just no determination of claims, because of robust security packages that employers require, retentions being withheld, and on the employer side, advance payments being made that's not allocated appropriately to their projects as it should be by the contractors, and then ultimately the contractors just can't pay those advance payments back. And then force majeure, which is a big bone of contention in South Africa, because we have plenty of issues which could or could not, or might not be force majeure. And so almost always force majeure becomes a very fact-intensive inquiry, and there's no real answer yet to whether something like construction mafia or strikes and lockouts is a force majeure. And often you can argue that based on the facts of a particular matter, it should not be seen to be a force majeure. Okay, and then key factors, the converse of the main causes. The key factors in reducing your disputes is to have a user-friendly contract, so something that your project manager understands and your project management team understands, so that they can properly implement it. A fair allocation of risk, because if there's a fair allocation of risk, that means the parties can properly assume those risks and manage those risks. If it's not fair, and there's a real imbalance, then you're going to run into problems with the party who has the risk allocated to it not being able to properly manage or control the risk. Improving cash flow is key, and you need to do that through good payment regimes in the contracts. However, even if you have good payment regimes, these mechanisms will be of little value if you do not combine them with good enforcement provisions in the contracts as well, so that you create a discipline between the parties to properly and promptly pay for what is due to them and avoid disputes around that. And then Encouraging and facilitating collaborative work is something that's we in South Africa struggle quite a lot with. Parties within the construction industry typically don't collaborate as they should. Although if parties do use the collaboration methods and openly and honestly talk about the issues that they're experiencing on site and debating how to mitigate those issues or better manage those issues, you might see a lot less disputes. That's coupled with good communication between the parties. Often contractors don't want to issue notices because they feel like that's going to constrain their relationships with the employers. However, you don't issue your notices and you don't have those collaborative facilitations processes, then you also won't have the opportunity to sit with the employer and try to resolve those. And then resolving issues quickly. Often parties leave all their claims until the project is finished because now they don't need a good relationship anymore. And then they just submit everything at once and it becomes a bit of a dog show. Okay. So what are some dispute avoidance techniques? And we've run through some of these already, but these techniques are really something that you should not just try as a project manager or as a contractor to implement, but also try to have in the contracts to encourage parties to kind of have these techniques and use these techniques. So good management, clear contract documentation, partnering and alliancing mindset. You have to have good project management, you have to have good client management, good contractor management, and whoever does the design needs a really good design management team management. Record keeping is key, especially when you already submit your claims. You need to be able to submit the relevant documentation and not leave it until you're in dispute. And as you said, good payment practice. So avoiding a dispute really means you have to be proactive about it. And in terms of NEC4 and FIDIC 2017, they have these positive dispute avoidance mechanisms implemented into them, and we'll look at them in a bit. This is different from the old dispute resolution regime where a matter is referred to someone in order to make a determination. It's now more of a proactive approach by all the parties to try and get a resolution. So some of the models which we see within this regime, this positive dispute avoidance regime being proactive, is parties can have dispute resolution advisors on board throughout their project. They can have the standing type dispute adjudication boards. Under the new contract, there's what's called dispute avoidance and adjudication boards, again, a standing type board, and dispute review boards. So those are generally the mechanisms that we see that can be implemented to help the parties with dispute avoidance if they can't manage it between themselves only. Okay, so I think we're going to move over to FIDIC. So in terms of, let's check there. In terms of the new FIDIC 2017, we have got what is called DAAB, Dispute Avoidance Adjudication Board. And it's supposed to be a standing board. And the aim is for them to provide assistance throughout the project through informally discussing issues as and when they arise with the parties and attend to resolving it. Alternatively, the DAAB can also be approached by the parties to make a joint request for them to become involved in a particular dispute. So it's very important to note that the DAAB has got this type of authority. It can actually, of its own accord, identify an issue and then discuss this issue with the parties because they already can see it's probably going to lead to a dispute if it's not resolved, or it can sit back and wait and let the parties tell it when the parties need it. So in terms of 2017 FIDIC clause 21.3, a joint request can be made at any time by the parties on a matter that's an issue or on which they have a disagreement. And it's really aimed to be informal assistance by the board. They can raise issues at any meeting, they can visit the site, they can do a Teams meeting with the parties. It's really informal process and really just aimed at the best of the benefit of the project. Okay, so just there you can see we've got the 2017 dispute avoidance mechanism in clause 21. I'm not going to run through all of this with you. Safe to say that there is a requirement to try and avoid disputes before you can actually refer a matter to your DAAB for a determination. Okay, and then there's a similar mechanism that was introduced into NEC4. Also now a new clause for dispute avoidance. Just get it. So in terms of clause W3, that's not it on the board. Yeah, it is. Yeah, clause W3. That's a new clause that was introduced in NEC4, and that whole clause just relates to the dispute avoidance mechanism before you actually refer a matter to dispute resolution. So again, in terms of the NEC, as we discussed yesterday, you actually have to choose this method if you wanted to apply. But it's certainly something that I think parties should consider as opposed to just the normal regime of going to dispute resolution. Okay, so just the key differences between the two dispute avoidance mechanisms in FIDIC and NEC. In terms of NEC, the parties must refer all of their potential disputes to a DAB as part of a dispute avoidance process. In FIDIC 17, the parties can request to involve the DAB on a voluntary basis for whichever claims they feel they need the DAB present. NEC, again, that dispute avoidance process must be followed before you refer the matter to arbitration. In terms of FIDIC, the parties must agree to request the DAB's assistance or involvement. Otherwise, the problem cannot be dealt with by the DAB. So the DAB can raise an issue, but the parties must agree that they want the assistance. And then there's informal discussions with recommendations by the DAB. The advice is not binding. The parties are then free to either implement the recommendations or refer it to the DAB for a determination. And the benefit of the FIDIC 21.3 clause is to encourage parties to prevent or to resolve disputes as early as possible. Hopefully to avoid arbitration. And then for both of them, the dispute avoidance mechanisms are intended to keep the job going and keep the cash flow going. So that smaller role players such as subcontractors are not impacted in the way that they usually are when they have to wait for a dispute resolution process to finish before they can get some cash in their pockets or have an issue resolved.
Okay, now we're moving on to consider the specific dispute resolution clauses in the FIDIC Red, Yellow, and Silver 1999 edition. Okay, so firstly, clause 20.2 deals with the appointment of the Dispute Adjudication Board, which is referred to as the DAB. Disputes will be adjudicated by the DAB, and the parties will jointly appoint the DAB within 28 days of the party giving the notice of intention to refer any of the disputes under those contracts. The DAB will comprise either one or three qualified persons. If the number is not stated and the parties do not agree, it can be stated in the appendix, and the parties do not agree, then the DAB will be comprised of 3 members. Just to mention that, as we discussed yesterday, that's one of the reasons, again, why it's important to ensure that those appendices and contract data are completed, because if it's not, then the contract doesn't really function in terms of the variables that the parties need to agree on. The parties will consult both the members that they've nominated as part of the 3-member DAB, and will agree on the 3rd member, who will then be the chairperson of the DAB. If the list of potential members is included in the contract, the members will be selected from such a list. The agreement between the parties and either the sole member of each of the 3 members will incorporate by reference the general conditions of the dispute adjudication agreement in the appendix. The terms of remuneration of the members of the DAB will be mutually agreed by the parties when agreeing the terms of their appointment. Each of the parties will be responsible for paying half the remuneration of the DAB. If at any time the parties agree, they may appoint a qualified person to replace any of the members of the DAB. The appointment of the members will become into effect if a member declines or is unable to act. The replacement will be appointed on the same in the same manner. The appointment of any member may be terminated by mutual agreement, but not acting alone by any of the parties. Unless otherwise agreed, the appointment of the DAB will expire when it has given its decision. Then we'll move on to clause 20.3. Clause 20.3 deals with the failure to agree on a dispute adjudication board. If the parties fail to agree on the appointment or the replacement of any of the members, then within 42 days, the appointing entity or the official name in the tender appendix will, upon the request of either or both of the parties and after due consultation, appoint this member. Such an appointment is final and then conclusive. Each party, again, is responsible for paying half of the remuneration of the appointing entity or official. Clause 20.4 deals with obtaining the DAB's decision. If a dispute arises, then after a DAB has been appointed, either party may refer the dispute in writing to the DAB for a decision. For a DAB of 3 persons, it will be deemed to have received the reference of a claim when the chairman receives it. Both parties is required to make available all information relevant to the claim, access to the site if it's necessary, and the appropriate facilities that may be required to make a decision. The DAB, that's just another provision, is in the clause is that the DAB will be deemed not to be acting as arbitrators. what is important in terms of timelines is that the DIB must, within 84 days after receiving the reference of a claim, give its decision. The decision must be reasoned and state, it must be reasoned. Sorry, I'm just thinking in practice, sometimes you get decisions from the DIB that doesn't really address all the reasons properly, and that is quite detrimental to the parties and the intention of having this dispute referred to adjudication. If neither of the parties has paid any of the invoices that's due to the DIB in full, then the DIB has the right to retain the decision until all its invoices have been paid in full. The decision that is made by the DIB is binding on both the parties and then have to give effect to it unless and until it is revised by amicable settlement or by an arbitral award. The contractor is obliged to proceed with all its obligations under the contract pending the adjudication proceedings, unless the contract is obviously abandoned, repudiated, or terminated. Then, if either of the parties are dissatisfied with the DIB's decision, or the DIB fails to give reasons for its decision within the prescribed time period, it might give notice of its dissatisfaction within 28 days of receipt of the decision, or if the DIB failed, within 28 days of the failure to give the decision. In that notice, the party must state that it is given under a particular subclause, the relevant subclause, and will set out the matter in dispute and the reasons for why it is dissatisfied with the DIB's decision. Neither party will have the right to proceed to arbitration unless it gives this notice of dissatisfaction. The decision of the DIB is final and binding on the parties if no notice of dissatisfaction is provided. Then I'm moving on to clause 20.5 that deals with amicable settlement. If there's a notice of dissatisfaction, both parties must attempt to settle the dispute amicably before commencing any arbitration. Unless both parties agree otherwise, the arbitration will commence then on or after the 56th day after the notice was made. And that rule applies even if the parties the 56-day period will apply even if the parties did not attempt to settle the matter. Then arbitration is provided for under clause 20.6. Any dispute in respect of which the DIB's decision has not become final and binding will be finally settled by international arbitration. So this will be done under the ICC arbitration rules by 3 arbitrators appointed in accordance with the rules, the ICC arbitration rules, and conducted in the language defined in clause 1.4. The arbitrators will have the power to open up, review, and revise any certificate, determination, instruction, opinion, or valuation of the engineer and any DIB decision relevant to the dispute. Nothing will disqualify the engineer from being called as a witness and giving some evidence if it's called to do so. The parties will also not be limited to give evidence or arguments that was previously before the adjudicator. And then any decision of the adjudicator will be admissible evidence. The arbitration may be commenced prior to or after completion of the works. And then again, the clause also provides for the fact that the parties' obligations under the contract will not be altered as a result of these proceedings. Then clause 20.7 deals with the failure to comply with the DIB's decision. If neither party gave notice of its dissatisfaction and the DIB's decision has become final and binding, and the party then fails to comply with it, the other party may refer the failure to arbitration without the need for amicable settlement. And then expiry of the dispute adjudication board's appointment, that's dealt with under clause 20.8. So if a dispute arises and there is no DAB in place, then the dispute may be referred directly to arbitration. So that deals with all the provisions in respect of the Freddie Gredier and Solder 1999 edition, and I will move on to the Freddie Gredier and Solder 2017 edition.
Yes, I'm not going to go through the whole process because it's very similar to what it was, except for the clause 21, which involves the DAAB. In terms of arbitration, the arbitration clause, one significant change that was made is that the following clause was included there. In any award dealing with costs of the arbitration, the arbitrators may take account of the extent to which the party failed to cooperate with the other party in constituting a DAAB. And this is quite significant because what we do see is that the parties, obviously, in terms of these contracts, almost always endeavor first to agree an adjudicator, or in this case, DAAB, if they hadn't done that at the outset. So if they don't have a standing DAAB and they have an ad hoc appointment that needs to be made, they have to agree who the adjudicator is. If they can't agree that, then obviously they have the nominating body who will decide on their behalf, which is not always the best option. And so if either party causes a delay in having the DAAB appointed, and that kind of affects the outcome of the other party's claim in arbitration, or seems to affect it, then the arbitrator can take that into regard when it makes its cost order. And that's clause 21.6, one of those paragraphs. And then another change is in terms of the amicable settlement. Regardless of when the parties actually reach the settlement or not, they can move on to arbitration after 28 days. And then finally, in terms of clause 21.7, if an award requires a payment of an amount by one party to the other party, then that amount shall be immediately due and payable with any statement or notice. And so obviously that just makes enforcement easier for the party who needs to get payment. And those are really the only significant changes from 1999 to 2017. So Diana will take us through Freddie Green 1999.
The Freddie Green 1999 provisions in respect of dispute resolution is dealt with under clause 15. So any dispute between the parties will be referred to adjudication unless it's settled, but and the adjudication will be governed by the rules for adjudication. The adjudicator is usually appointed by agreement between the parties. Alternatively, in accordance with the rules, if the parties fail to reach an agreement. Then, if there's any notice or dissatisfaction with the adjudicator's decision, then there must be a notice provided within 28 days of such a decision. If the notice is not given in this way, the decision will be final and binding on the parties. If the notice is given, the decision will be binding on and the parties will give effect to unless and until the arbitrator revises the decision. And then if in terms of arbitration, a dispute that has been the subject of the notice of dissatisfaction will then be finally settled by a single arbitrator under the rules in the appendix. So if there is no nomination in the, or if there's an agreement between the parties in respect of the arbitrator that should be governing conducting the proceedings. The appointing authority specified in the appendix shall do the appointment. The arbitration can obviously also include a hearing, and that will be held at the place that's also specified in the appendix. And that's it in terms of the provisions that deals with the dispute resolution under the Green Book.
Okay, so in terms of 2021, again, not much has changed, but there is a type of a dispute avoidance clause that's included in 14.1.2. If the parties so agree, they may jointly request the adjudicator to provide assistance and or informally discuss and attempt to resolve any issues or disagreement that may have arisen between them during the performance of the contract. Or if the adjudicator becomes aware of any issue or disagreement between the parties, he or she may also invite the parties to make such a joint request. And then neither the parties nor the adjudicator shall be bound in any future dispute resolution process by any opinion given by the adjudicator in this informal assistance process. So that's really FIDIC's attempt in the Green Book to also include a dispute avoidance mechanism in the short form contract. And then much of the rest is the same. You've got amicable settlement, and if that fails, you've got adjudication as the first tier, and you've got arbitration as the second tier. And irrespective of whether a party is dissatisfied with an adjudicator's award, the decision shall be binding as it is under all of the FIDIC books. And the parties must give prompt effect to it until and unless it's revised in arbitration. And so one of the key things here is that where a party fails to comply with the decision of the adjudicator, whether binding or final and binding, the other party may, without prejudice to any other rights they may have, they may refer the failure itself directly to the arbitration. So that aligns with the other 2017 clauses that we saw for the regular and silver books. And then in such an event, the arbitrator shall have power by way of summary or other expedited procedure to order, whether by an interim or provisional measure or an award, the enforcement of that decision. So this is quite important. Generally, parties approach the courts to enforce adjudication orders. But through this provision, which is 14.1.7 in the Green Book 2017, the contractor or the employer can actually approach the employer, the arbitrator, to make an award or keep interim relief for enforcement of the adjudicator's award. And in the case of a binding but not final decision of the adjudicator, such interim or provisional measure or award shall be subject to the express reservation that the rights of the parties as to the merits of the dispute are reserved until they are resolved finally. And then any interim or provisional measure or award enforcing a decision of the adjudicator which has not been complied with, whether such decision is binding or final and binding, may also include an order or an award of damages or other relief. So that is also quite a significant change. And then in terms of the arbitration process, as before, a notice of dissatisfaction is required before you can go to arbitration. It's typically based on one arbitrator, and that arbitrator has full power to open up, review, and revise any certificate, determination, instruction, opinion, or valuation of the engineer. And obviously, the arbitration process is not limited to previous evidence or arguments, so the process can be started afresh on new evidence as well. Just quickly have a look. I think that is, yeah. That is it for the 2021 FIDI Green, which is the change to the 1999 FIDI Green. So you'll see this is the only book that was revised in 2021, whereas the others were revised in 2017. Okay, so lastly, we are going to deal with dispute resolution for NEC 3 and NEC 4. And as you know by now, the dispute resolution clause is set out in clause W, secondary or optional clause W. And I'm just going to quickly take you guys through what it provides. As we've said yesterday, only W1 will apply to South Africa. So W2 is ignored for our purposes. Okay, so we have a similar process as with FIDIC, being adjudication as a first tier and then arbitration or review by the tribunal as the second tier. The one thing that you should know about the dispute resolution provisions in the NEC is that, or NEC 3 specifically, is that it has what is referred to as an adjudication table. And that is quite important because this table sets out timelines within which you have to refer a matter to the adjudicator. So you'll find the adjudication table in clause W13. And there's 4 specific disputes or 4 types of disputes mentioned in the first column. It then says which party should be referring that issue to the adjudicator in a second column. And in the last column, it then gives timelines within which this should be referred. So the disputes that it talks about is either an action of the project manager or the supervisor, or the project manager or supervisor not having taken an action, or a quotation for a compensation event which is treated as having been accepted, and then any other matter. So where the dispute is about an action of the project manager or supervisor, the contractor has to give notice between 2 and 4 weeks after the contractor's notification of the dispute. It needs to be referred to the adjudicator. Where the dispute is about the project manager or the supervisor not having taken an action, it also has to be referred by the contractor. Again, it has to be referred between 2 and 4 weeks after the notification of the dispute to the employer. And then for both of those, the notification itself must not be made more than 4 weeks after the contractor becomes aware of the action or the inaction. So you can see that the timelines for referring to the adjudicator is quite short. So you've got 4 weeks to notify, and then you have only 2 to 4 weeks. I don't know why they just didn't make 4 weeks, but 2 to 4 weeks to refer to the adjudicator. Then if the dispute is about a quotation that's deemed to have been accepted, the employer is required to refer the matter to the adjudicator. So if the employer doesn't want that deemed accepted quotation, a compensation event to be implemented, or quotation to be implemented, then it must refer to the adjudicator. Again, it has 4 weeks to notify that it will refer, and then 2 to 4 weeks after that notice, it has to refer to the adjudicator. And if it's about any other matter, then either party can refer it to the adjudicator. And strangely enough, in relation to any other matter, there's simply a requirement that the referral needs to be between 2 and 4 weeks after notification of the dispute, but there's no provision for a time period within which the notification itself must be given. Okay, so these times for notifying and referring may be extended by the project manager if the contractor and the project manager agrees to an extension before the notice or the referral is due. The project manager notifies the extension that has been agreed to the contractor, and if a disputed matter is not notified and referred within the time set out in this contract, neither party may subsequently refer it to the adjudicator. So there's quite a strict time bar in terms of referring a matter to adjudication. And then the rest is quite similar to the FIDIC type regime. Again, if you want to refer to arbitration, it must, firstly, you have to have a notice of dissatisfaction, having been notified before you can go to the tribunal. And a party may not refer a dispute to the tribunal unless that notice is given within 4 weeks after the adjudicator's decision. So yet again, another time bar there as well. And that, I think, is it for NEC 3 and the dispute resolution process in terms of that. It's quite straightforward. And then NEC 4 really doesn't have many changes. The only significant change is that there's an additional step prior to the adjudication, and that is referral to the senior representatives. So each party has a senior representative who will meet in an attempt to resolve a dispute before it can be referred to adjudication. These senior representatives are set out in the contract data, so already at the start of the contract. And they will attempt to close out disputes before it's escalated in terms of cost and tension and before it goes to adjudication. A list of issues that's not agreed can then be referred to adjudication within 2 weeks after the senior representatives process has finished. And then the adjudication table has just been replaced by what's now called a dispute reference table. And as we've already discussed, we've got this introduction of W3, which is a dispute avoidance board that consists of 1 or 3 members, and they are required to visit the site to inspect the progress of the works and to try and assist the parties to try and avoid disputes. If the DAAB does make a recommendation in terms of clause W3, and that recommendation is disputed, then the party must issue a notice within 4 weeks before referring then that dispute to the tribunal. So that's similar to NEC 3. And those are the only changes.
We are now moving on to the dispute resolution clauses under the JBC's Principal Building Agreement of the 2018 edition. So the dispute resolution process starts under clause 30. 30.1 requires the parties, well, what is interesting, it says that should any disagreement arise between the employer or the principal agent or an agent and the contractor. So it includes the principal agent, which is interesting, and the contractor arising out of concerning the action or inaction of the employer or the contractor or any other matter concerning this agreement. Either party may give notice of disagreement to the other. Then firstly, the party should attempt to resolve this disagreement and then report such resolution in writing and sign it if it is resolved. If the disagreement is not resolved within 10 working days of the receipt of the notice of disagreement, then the disagreement is deemed to be a dispute. And the dispute shall then be referred to adjudication within 10 working days of the expiry of the period, which is the 10 working days, by means of a notice of adjudication. And the notice of adjudication must clearly define the scope of the dispute and the relief that is required under the adjudication process. And then the last clause under this first section in the dispute resolution clause deals with if there's a failure to comply with any of these terms or clauses, then the parties may refer the dispute to arbitration without having to first refer it to adjudication. The clause 30.5 deals with mediation. And it entitles the parties to refer the dispute to mediation at any time. And during that period, the adjudication and arbitration proceedings will be suspended. In terms of the mediation process, the parties will agree on the appointment of a mediator, the outcome and the procedures that will be followed. Regardless of the outcome of the mediation, the parties shall bear their own costs and they will share the cost of the mediator. And then we can move on to adjudication. Adjudication is conducted in terms of the JBCC's own rules for adjudication, current at the time when the dispute is declared. And then the following shall apply in terms of the adjudication process. The adjudicator shall be appointed by the nominating body in the contract data. And the rules shall also, that is applicable, shall also be stated in the contract data, or it shall be agreed between the parties and the adjudicator. If there is no agreement between the parties, then the adjudicator shall determine which rules will be applicable to the adjudication proceedings. Then what's interesting in this clause is also deals with the fact that neither party is entitled to legal representation unless it's specifically agreed otherwise by the parties. A determination by the adjudicator is immediately binding and shall be implemented by the parties, notwithstanding that they might refer this dispute to arbitration. If either one of the parties is dissatisfied with the determination, they will also then again give a notice of dissatisfaction within 10 working days of receipt of the determination. The period of 10 working days may be extended if it's agreed between the parties and the adjudicator. If the adjudicator does not give a determination within the specified time period, then either party may also give a notice to the other party and the adjudicator that such determination is not received, and his appointment shall thereupon automatically be terminated. And such dispute shall then be referred to further adjudication or to arbitration at the option of the referring party. The adjudicator shall not be eligible for subsequent appointment as the arbitrator. And that concludes the provisions that deals with adjudication. In respect of arbitration, the contract provides that arbitration shall not be construed as a review of the adjudicator's determination. Any determination by the adjudicator will remain in force and the parties will continue to implement the award unless it's overturned by arbitration. So, as you know, the nature of arbitration is that the dispute will commence afresh or anew. The referring party in this adjudication shall be referred to as the claimant in the arbitration. The arbitrator is nominated by the nominating body in the contract data and shall be deemed to have been appointed by the parties. The applicable rules is also stated in the contract data, or the parties again can agree to the rules that should be applicable to the proceedings. The arbitrator's award will also be final and binding on the parties. Then there's some general provisions at the end of the dispute resolution clause, which just provides for that the employer may consent to the joining of any subcontractor with the contractor as a party to any of the proceedings. Where the parties fail to specify a body to nominate the adjudicator or the arbitrator, the referring party shall have the right to choose a local recognized body to suggest one or more persons with appropriate skills to be appointed as an adjudicator or arbitrator. And then lastly, the party shall continue, again, this is restated, is that they should perform their obligations irrespective of the dispute resolutions proceedings pending. That brings us to the end of this. So I think we can continue with any questions that anyone may have.
Okay, so I don't think if anyone has any further questions. Wait, there's some that comes through. Michelle, if you have any questions, you can send them on to Betty, and she'll put you in touch with us in terms of answering questions. The only caveat I'll give here is that we can't give legal advice, but we certainly are available to answer any questions that you've got. Michelle's asking why education is not being used more often in South Africa. And so, as I said, in terms of construction matters, it's very widely used, but in terms of commercial matters, we don't see it often. And I think it's because of a lack of knowledge of the benefits that adjudication can have, together with a lack of training appropriate adjudicators. So at the moment, within the construction industry, we are using mostly the Construction Council, which is not always ideal. They have busy schedules, they're running practices, some of them are acting judges, and so at the end of the day, some of them tend to be a little bit too formal and legalistic about the process. Some of them have too busy diaries to allow a quick process. And then just in terms of commercial matters where you might have other types of adjudicators like QSs, engineers, architects, whoever, I just think that there is probably a lack of training in South Africa on how an adjudication process should effectively be used. From clients' perspective, it's not pushed because I don't think there's enough knowledge, both from lawyers advising clients and clients themselves. There's not enough knowledge of what an adjudication is. Everyone understands an arbitration, but very few people really understand what adjudication is and how that can be helpful. The cost of a DAAB. So generally what they do is they would charge their hourly fees as a normal adjudicator, but they could come to various types of arrangements. They can come to a retainer arrangement, or they can come to an arrangement that they will be paid per hour actually worked. On top of that, you will have to reimburse them for any traveling and accommodation fees if they have to do site visits or meet with parties. Particularly because the members are obviously not all located in the same area, and also not where the project is necessarily. So it's really just it's a negotiation between the parties in the DAAB, but it is rates-based. Okay, a client approaches us, the subcontractor and wants us to draft a memorandum of agreement. Will we need the books referred above, or is there a standard form of flexible contract? So a memorandum of agreement is something different from a contract. And so if you intend to use one of the standard form contracts, you should probably include that in the memorandum of agreement to say if you will be using this or that type of standard form contract. Hope I understand the question correctly, but yeah, I mean, in terms of the standard forms, you either use the standard forms or you don't. If you don't use the standard forms, then you need to draft a bespoke contract. Okay. Any other questions? Thank you very much to everyone who took the time to listen to us. I really hope that it's been insightful and helpful. We can never get through absolutely everything we need to know, but I hope we've given you a good overview. In terms of where you can get these forms, unfortunately, you have to buy them. They are copyrighted, so please do not use anyone's copy. You have to buy them from FIDIC, NEC, and JBCC on their websites. You can buy the hard copy, or you can buy electronic versions. Guys, well, thank you very much. As I said, any further questions, please feel free to send them through to Betty, and she'll be in touch with us.